quote of the land, and yet their application with some sort of understanding was taken up. But I tell you, whoever entertained the applications and fixed them were not really fully aware of what mental illness is, which we learned much later. But somehow the matter was taken up in that sense. So let me also, at this time when we started looking at the case, we were hearing arguments and all, and we realized that look at the statutory landscape. What are the laws on the subject? The law on the subject was Lunacy Act 1912, and there's a gap of 89 years. We live with Lunacy Act for 89 years, which just talks about an idiot and a lunatic, and that's about it. And then, after 89 years, in 2001, you have the Mental Health Ordinance. For the first time, it defines what mental illness is and other shades and nuances that are attached to it. But that also remains on the statute book for a while, because 2001, and now this case comes up much later. So the statutory landscape wasn't very encouraging, wasn't really there. And I think that's important to understand, that people never understood because there was no definition. There was no law talking about it. We had just left it in the corner like Lunacy Act 1912, okay, forget it, untouched law. And I think that's the awareness issue. That's why the sensitivity wasn't there. That's why there was no responsiveness on the part of judiciary or others, you see, because there was no law looking at this area. So total lack of sensitization. If you look at the case law, that's also very depressing. I mean, while the time we are sitting and looking at this case, we look at our jurisprudence, we always do, we look at our past cases, and wasn't encouraging at all. Once again, we thought that there was no sensitization. Judgment said that, the assumption is that everybody is sane. We're all normal, says the assumption, unless something else is proven. Now, how would a villager come forward and prove such a technical thing, that there is mental illness, and then how would she prove it? I don't know. So it was, many cases were dismissed on this ground that, oh, sorry, the accused failed to prove that there was mental illness. And today I understand how technical it is and how sophisticated and complicated it is, and you're expecting somebody from a remote district to come forward and prove it, that I have, or my son or my brother or my husband has mental illness. So it was just left to the accused to prove, and otherwise they were convicted and they were ignored. So if you get a feel of the jurisprudence over the years, when we sat on this judgment, we thought, nobody really cared. There was no awareness, total insensitivity, and totally unresponsive towards the issue of teaching us about all this. And we started learning, and so we thought, let's look at, so the judgment is structured on all the stages of the trial. What happens if at the time of the commission of the offense, the person is suffering from mental illness? What when during trial, he's to take up a defense and he suffers from mental illness? What at the time of execution, when he's about to be taken to the gallows, he suffers from mental illness? So these three stages were examined by the court, even though the court only had post-conviction matters, but they opened it up. So that's something also that I want to talk about. The judgment goes beyond the the scope of the case that was brought before the court. So the three stages were discussed in detail. What helped us tremendously was, of course, the Mental Health Ordinance itself, which we started off reading for the first time in 2000. It's a 2001 law. And it talks about mental disorder, mental impairment. These terms were new to us. That's why I want to sort of read this, and I want everybody to understand that these are the terms that exist. So mental disorder, mental impairment, severe personality disorder, severe mental impairment, mentally disordered prisoner. And these terms weren't in our literature. How would we decide a case? So this is very important that the legislation helped us get started. And then, of course, there were decisions from foreign jurisdictions that came forward. We went through that, and we went through a number of other material that was provided. International conventions were provided, and we started understanding that how far, we were from where the world is. We were really far behind. So the first thing that really comes out of the judgment, and I just want to highlight what we've really held, you see, what the judgment talks about, is the definitional framework. We've actually now made it quite clear. And this is no end, you see. We will be developing, and I'll be talking about revisiting Safiya Bano if chance is given to us at some stage, and I'll talk about some of the ideas for the future. But what this judgment comes out with is the definitional framework. Recognition and understanding of medical science which is constantly evolving. So this is a material judgment which says, please open your doors, courtroom doors, and bring science in. You can't decide matters without science. And not only in mental illness, you talk about environment, you talk about climate change, you talk about gender, you talk about rape, you talk about science. Science is such an important part of jurisprudence, and for us to understand, judges who do not understand science, who are not in touch with science, will not be able to produce jurisprudence. So I think this judgment opens the door. So some of the things that you might not, by reading it, appreciate or feel, I just want to highlight as a judge, I feel it's a great judgment which opens doors for science to walk into our courtrooms. And I think we should do that. So let me quote some of the passages from the judgment, because Justice Mansoor is not here, so credit goes to him, but let me read it. On the definitional framework, therefore we are of the view that a limited definition of the term mental disorder or mental illness should be avoided, and the provincial legislature may, in order to better appreciate the evolving nature of medical science, consider to appropriately amend the relevant provision of mental health laws to cater for medically recognized mental and behavioral disorders as notified by WHO through latest edition of ICD. Basically, the judgment opens the door of be current. You see, keep on bringing the new changes evolving in the area of medical science or in the area of mental illness. It goes further and says, we consider it appropriate to direct that the terms unsoundness of mind and unsound mind occurring in PPC and CRPC and the prison rules be substituted with terms like mental disorder, mental illness. The term lunatic, which occurs, shall also be substituted appropriately. So we discarded the words. So that was really, putting the past behind and moving forward. So getting rid of the words, the literature that was in existence at that time. So that's one area that we did, and I'm very proud of that. Then we talked about different stages, which I mentioned earlier. We talked about different stages of the criminal trial and how mental illness has an effect. We talked about the stage where the commission of the offense, at the time of the commission of the offense, the person suffers from mental illness, or during the trial, or at the execution level. And we talked about a lot of law, which is already mentioned in our criminal procedure code in PPC. And we finally hold that, and I want to read it like this, because I think a lot of young lawyers could take what I'm trying to say and develop it further, you see. Even though the judgment says that the accused has to prove at the initial stage, in the first instance, where he says that at the time of the commission of the offense, he was suffering from the mental illness, the onus under the evidence law is also on the accused. But then it opens the window a little, and it says if there's any other material on the record, even brought in by the prosecution, could be relied upon by the accused. And also, I would read it this way, that I think prosecution ought to also satisfy the court that no, he's not mentally ill. And I think we need to push it in that direction. When I read from that portion, it is the basic, and I use these words, and I think there's a lot of bandwidth there. It is the basic duty of the prosecution to prove its case against the accused beyond reasonable doubt. And within its fold, you could say that there was an issue regarding his mental illness. So please establish that also. And the prosecution will not be absolved of this duty, if the accused is unsuccessful in proving the plea. So if he might be unsuccessful, the prosecution has to establish that he's not mentally ill. And I think that is the direction. So basically, we're putting the prosecution on the mat also. Then we go ahead, and during the trial, the law says that the trial will stop because it will be kept pending if it's discovered. But what's important is that the law simply said that the magistrate or the court will look at the person, maybe, seek some opinion here or there, and it was very casually being done, you see. I fail to understand as a judge that how would I ever, sitting at the Supreme Court with all this judicial experience, tell that a person suffers from mental illness. I mean, something could be very obvious, but you can't really, you see. So I don't think it's within my domain to even get into that area. And the minute anything is on the record which even slightly points towards that, I think one should go ahead and hold a very serious inquiry. And that's what the court, and that's where the departure takes place, and I think it becomes a landmark judgment. It says, hold an objective inquiry. I'm nobody. I don't know who this person is, but you sense that there is something, or even if you don't sense, there's something on the record which says that he's suffers from mental illness. An inquiry ought to take place. And I quote, once the court has formed a prima facie tentative opinion that the accused may be incapable of understanding the proceedings of trial or make defense, it becomes obligatory upon the court to embark upon conducting an inquiry to decide the issue of incapacity of the accused to face trial due to mental illness. Medical opinion is a sine qua non in such an inquiry. Now, this is where we bring science in again. We are not going to decide. Let the experts do the job. And experts sitting there, I mean, they did a wonderful job anyway. For this purpose, the court must get the accused examined by a medical board. Now, medical board comes into the literature for the first time due to this judgment. To be notified by the relevant government, consisting of qualified medical experts in the field of mental health, to examine the accused person and opine whether accused is capable or otherwise to understand the proceedings of trial and make his or her defense. The report opinion of the medical board must not be a mere diagnosis of mental illness or absence thereof. It must be a detailed and structured report. This is very important. Structured report with specific references to psychopathology, if any, in the mental functions of consciousness, intellect, thinking, mood, emotions, perceptions, cognition, judgment, and insight. You see, there might be words coming from Professor Rana, but we've adopted them now. They're law of the land. The head of the medical board shall then be examined as a court witness, and such examination shall be reduced in writing. Both the prosecution and defense should be given an opportunity to cross-examine him in support of their respective stance. Thereafter, if the accused wishes to adduce any evidence in support of his or her claim, she should be allowed to produce such evidence, including expert opinion, with the prosecution given an opportunity to cross-examine. So, this is taking things further, because the law did not talk about it. The law said, well, we'll just make a tentative understanding, and we've been rejecting that over the years. The last 80 years or so, since the Lunacy Act, we've been dismissing cases because we think, no, he's not a lunatic, maybe. So similarly, at the execution stage also, this is where the retributive justice concept comes in, whether at all, how would you serve a retributive justice or bring somebody subject to retributive justice who does not understand what he's being, punished for? So when it comes to execution, and suppose the person develops a mental illness, the court said that killing someone who has no capacity to understand his crime or punishment offends humanity. Lack of retributive value in executing a person who has no comprehension or awareness of penalties, existence, and purpose. You see, so it's very important that this execution cannot take place for a person who suffers from mental illness. And I'll be sort of submitting some of the other things also. We also relied on a number of international documents and treaties, conventions, Nelson Mandela rules, and there's a number of things. It's a wonderful read. Have a look. You'll find a number of things there. And I once again like to quote another important paragraph which sort of sums this up in the end, which talks about the execution in particular, because it talks about, as I said, about inquiry, which is a very important thing, an objective inquiry, and then now about the execution, that somebody suffering from mental illness will not be executed. You see, he will not be put to that that punishment. And I quote, after considering the material discussed herein above, we hold that if a condemned prisoner due to mental illness is found to be unable to comprehend the rationale and reason behind her punishment, then carrying out the death sentence will not meet the ends of justice. However, it is clarified that not every mental illness shall automatically qualify for exemption from carrying out the death sentence. This exemption will be applicable only in that case where a medical board consisting of mental health professionals certifies after